Okay, Shannon, you can put us on.
Okay.
Okay, Rulowitz versus Dreyer. Counsel, could you state your appearances, please?
Good afternoon, Your Honor. This is Stephen Boringer here on behalf of the plaintiff, Timothy Rulowitz.
Judge, good afternoon. Rick Girodad on behalf of both defendant directors.
Do you need either spelling?
No, I just need to know if their clients are here.
No clients are present.
Correct.
None here, Judge.
Okay. Mr. Girodad, this is your motion. Go ahead.
Thank you, Judge. Judge, did you have an opportunity to look over the reply brief at all?
I did.
Okay, great. As you'll note, Judge, there's no dispute that the plaintiff suffered a fractured sternum. However, there is a dispute as to the remaining alleged injuries to the knees, thumb, wrist, hips, shoulders. Judge, I reviewed virtually all the plaintiff's medical records before I took his deposition. And during his deposition, he candidly admitted regarding those particular areas, I'll just go one by one, regarding his knees, his answer, they said there wasn't anything broken, cracked, or anything. And I said, did you get any treatment for your knees? And he says, the hospital wouldn't do anything. Okay, did you get any treatment even after? And he says, no. Are you getting any treatment for them now? And the answer is no. And so I go on to the thumb. It's once again, any specific diagnosis for your thumb? And he says, it was a strained ligament. Any treatment other than a little bandage? Nope. Has it resolved? Yes. Once again, I move on to the wrist. Anything about the wrist? You had an MRI. Any type of ligament tear or damage? Answers no. Same thing with his thumb. Once again, any treatment other than a bandage? No. Has your problems with your wrist resolved? Yes. It just goes on and on. Same with the hips. Any diagnosis for your hips? No. Any treatment for your hips? No. So I don't think there's any doubt, Judge, that between the knees, thumb, wrist, and hips, there's no injury. In response, counsel provides no explanation at all as to how his client was somehow mistaken and that he actually had, in fact, suffered some kind of an injury he was otherwise unaware of. Rather, I apparently missed some type of seminar where you simply attach the biggest stack of medical records you can to your response in the hopes of there being some magic answer in there somewhere. But counsel's response refuses to indicate what's the injury to the knee, what's the injury to the thumb, what's the injury to the wrist, what's the injury to the hips, where are the medical records? None of it is in there, Judge. It's just a wild goose chase that makes references to records where Mr. Rulowitz simply says, my knee hurts, my thumb hurts, my wrist hurts. No diagnosis, Judge, no treatment. And we think we're entitled to summary disposition as to all four of those particular body parts. Now that leaves, we'll go to the ribs now, Judge. Do you want me to do them in order, Judge, or all at once, or how do you want it?
I don't care. It's up to you.
All right. Insofar as the ribs are concerned, Judge, when I took his deposition, I asked the plaintiff, I said, do you ever have any problems with your ribs before the accident? He says, no. And then it turns out that about maybe 6 weeks before this accident, he had injured his ribs in a fight or an assault with his stepson. That's what his medical records indicate, which in fact is borne out by the imaging taken on the day of the accident. The first x-ray taken of his ribs after the accident indicated a fracture exists in the ribs. However, a CT scan taken later that very same day, which of course, Judge, is more sensitive to a fracture, indicates that it's a callus formation. That means it's healing. And it also specifically indicates it's subacute. So that means it didn't happen in the accident. Once again, counsel's response, we get no explanation at all regarding what happened before this accident. Did he get into a fight? All he does is provide you with the first x-ray, which we know to be less than all the information we need here, Judge, which is the second CT scan. So we think we're entitled to summary disposition as to the ribs as well. That leads us to the sternum and the cardiac issue, Judge. And again, Judge, there's no dispute that there's a fracture of the sternum here. But there's also no dispute there's absolutely no treatment for this fractured sternum, none. Insofar as this cardiac situation is concerned, it's a vasovagal type of a reaction, Judge. It's to describe it in layman terms. If you're laying down and you stand up quickly, sometimes you get lightheaded, things of that nature. But when you look at his own doctor's medical records regarding this particular condition, it's clear that on the day after the accident, when they do a workup, telemetry has consistently shown diagnosis sinus bradycardia without any tachybradycardia arrhythmias. That means his heart is absolutely fine. There's no problem with that. And he does a follow-up 6 months later, and what his own cardiologist tells him is these pre-syncopal episodes are typical for vasovagal episodes. I've encouraged him to liberalize his fluid intake to avoid reoccurrence. So dehydration is causing this type of vasovagal situation. Again, no medical evidence that he suffered any type of cardiac injury in this accident, and we think we're entitled to summary disposition as to those two particular claims. Which leads us, Judge, to the shoulders, which is probably the most important aspect of this entire claim. This particular plaintiff, Judge, had years of shoulder problems, bilateral shoulder problems, injections, surgeries, the whole 9 yards, Judge. Importantly, he doesn't report any pain, any shoulder pain for 40 days, until 40 days after this accident. And when he does, he reports pain to both his shoulders, Judge. And if we ignore the virtual statistical impossibility that both shoulders, which he claims to have been injured in the accident, would both become somehow symptomatic 40 days after the accident at the same time, it's unbelievable, Judge. And now there's no medical evidence to support that there was any injury. And now this is not coming from my doctor, Judge. This isn't anybody I hired. This is Dr. Angelo Williams, his own doctor at Chelsea, who testifies, and I'll provide the court with just a couple of blurbs here. And we ask him very specifically, tendon tears, which is what he showed with one tendon tear in the right shoulder by MRI, Judge. And I asked the doctor, tendon tears can occur traumatically or over time, true? And he says, answer, or both. Question, or both. Do you have any idea what happened here? Answer, I don't. And Judge, this was not a short deposition. And if you had the time, and we provided you with his transcript, we went round and round with him trying to make sure that he didn't have testimony that would link any shoulder injury to this accident. And that's why, Judge, when you look at plaintiff's briefs, he provides you with quotes and statements like this. The plaintiff's symptomology was worse after the accident. Well, who cares? That doesn't prove that any injury occurred. And then counsel for plaintiff indicates, again, that the symptomology worsened, and that was consistent with the doctor's examination. Once again, so what? Who cares? Dr. Williams doesn't link any injury to the accident. Then counsel indicates the doctor's physical examinations, both range of motion and strength testing, are objective evidence of damage to the shoulder. Well, first off, that's not objective evidence. And second off, so what? What's the injury? There's nowhere in that deposition transcript does Dr. Williams testify, okay, here's what happened to Mr. Rulewitz's shoulder in the accident. Again, they're trying to claim that it got worse after the accident, but the doctor won't establish the injury to begin with. And when they're left with that, they start asking questions that are much more on the edge, if you will. And here I'll give you an example. Therefore, when you look at his history and the facts of what we do know, the accident was certainly a factor in leading to the right shoulder surgery. Answer, it appears to be. Well, that's pure speculation. Was a factor? What kind of a factor? I mean, and that's what happens when you ask the doctor the same question 15 different ways, trying to get him to give you causation testimony, which he clearly refused to do. Judge, we take discovery depositions of doctors for a reason. In this instance, a motion for summary disposition requires some type of a response that has a reasonable, admissible inference of causation. We don't have any of that here, Judge. When we look to what they're relying upon, and these are the quotes, and I'll just give you a part of the question. The motor vehicle accident impacted the need for the left shoulder surgery as well. Answer, it could have. But it's certainly possible given the facts. It's possible. The motor vehicle accident certainly could have aggravated the need for a shoulder surgery. Answer, it's possible. Well, Judge, it's possible, it could have, it appears to be a factor. None of that's enough. The law is clear. More likely than not is the standard, and that's what's required in response to a motion for summary disposition. And we think we're entitled to summary disposition as to the shoulder claims as well. Thank you.
Thank you. Response?
Thank you, Your Honor. Not sure exactly quite where to start. It seems like Mr. Giordad is trying to pick apart various portions of all of the injuries that Mr. Rulowitz sustained in this accident. And in reality, the statute requires that the court at this stage look at all of the injuries in their totality, not to piecemeal some of them out. Candidly, there were certain things that were sore or bruised after the accident that didn't have long-lasting effects on Mr. Rulowitz. Those would involve the knee. Those would involve the wrist and thumb. However, to say that he didn't get treatment is absolutely not true. He came out with the left wrist and thumb bandaged. There was no further treatment after that. He was told, and he testified that he was told that I believe his thumb or wrist was sprained at the time. That doesn't mean that those are kicked out, that they aren't severe injuries, because he did have other injuries that were severe. So if we look at that, we know that he had the fractured sternum. We know that there was actually a fragment that was displaced. And in addition, there was something called the retrosternal hematoma, where the bruise in the rather than those are important things. The fact that there isn't treatment for those, I guess meaning a surgery, doesn't mean that they aren't severe, doesn't mean that they aren't serious, and certainly don't mean that they didn't have an impact on his life. In fact, to the contrary, they did. There is no surgery that people do for ribs or for a fractured sternum very often, and it's rest. And we know that he was off work for 3 months because of that. On top of that, we have the shoulders. And we have some disputes on some of the other facts. So actually, before going to the shoulders, if you look at Exhibit B from the defendant's own brief, it's a note from January 30th where Mr. Rulowitz's history does state that he had some right-sided rib pain for 3 days, had some issue with the stepson, and then goes on to diagnose him with costochondritis acute, which is some swelling in the rib area. It didn't diagnose him with fractured ribs. What did diagnose him with fractured ribs was an x-ray. I understand that there was a CT scan afterwards, which says something a little bit different. It says that it looks like they're healed. However, one doctor did say that they were broken. And in addition, if you look at Exhibit 2, pages 2, 8, 9, 34, and 36 all have doctors who talk about broken ribs. In fact, pages 34 and 36 are from a week after the accident, where the doctor characterizes them as having been broken in the accident. Those are clear questions of fact with regards to the ribs. Going on to the shoulders, You know, if we look at pages 19 through 21 of Dr. Williams' deposition, and I think if you read those in their totality, and Judge, I don't want to waste your time with reading the entirety of a transcript, question and answer verbatim back to you, but they are very important pages. Because Dr. Williams did continually state in response to questions from both defense and plaintiff that it was possible, it may have. And on page 20, he was basically said, well, let me ask you this way. You can't state without looking at a pre and post accident picture if the pathology was definitely caused by the accident. And he agreed 100%, I can't. Well, that isn't the standard, that you need an MRI before the accident and an MRI the day after to establish it. What we do know is Mr. Rulowitz did have issues with both shoulders for a long period of time. We know that he treated with Dr. Williams in January and February, the 2 months before the accident. We know that his condition was getting a little bit better based on treatment he received from Dr. And this claim of 40 days without mentioning shoulder pain is a little bit troubling because the records are very clear. If you look at our Exhibit 2, pages 32 and 33, which are from March 22nd, 1 week after the accident, there's clear mention and complaints of right shoulder pain. There's an exam of it where it's tender, and they even take an x-ray of his shoulder. So to claim that there's this 40-day period is disingenuous at best. And I certainly didn't want to put Mr. Giordad on a wild goose chase of some kind. I mean, the records are in there and they state what they say. What Dr. Williams testified to is an accident can cause a torn rotator cuff. We know there was a torn rotator cuff on the right side because it was surgically repaired. He was asked if all of these things make sense. Was his condition better before the accident? Yes. Was it worse after? Yes. Mr. Giordad argued with Dr. Williams about whether or not his physical examination was objective or subjective. Well, that's a question of fact. When an orthopedic expert says it's objective the way I do it and then explains it multiple times, it's a question of fact for the jury. What we do know is that that examination showed his range of motion was different in addition to just the pain symptoms. And a jury can put that together. In 2018, there was a published opinion in the Court of Appeal, Patrick versus Turkelson. We mentioned it in our brief. In that case, it involved an individual who had lost hearing. And in that case, the audiologist said, well, I don't have a prior audiogram to know exactly what their baseline hearing was before. In that case, the doctor said, well, people can lose hearing based on the aging process. And in that case, the doctor also said, well, just loud sounds can cause an injury to an ear. It doesn't have to be a car accident. That's very analogous here. We don't have an MRI the day before, but we have one afterward. And we have a doctor who said that it didn't show any signs of being a chronic tear because there was no atrophy in the muscle. We have a doctor who said, yeah, it could be the aging process or it could be a car accident. I've seen it before. And there's certainly other things that could cause a rotator cuff tear. But that's why it's up to the jury to decide, because in that Turkelson case, in Patrick versus Turkelson, the Court of Appeals overturned summary disposition and said there is a question of fact here. That testimony can stand. That testimony allows the jury to put reasonable inferences together to establish an injury related to the accident. The jury does not have to, and they don't have to here. But to say there is not enough evidence for the right shoulder to link it to the accident is not accurate. It's all there, and it can be tied together. For the left shoulder, it's an aggravation type argument there. And Dr. Williams agreed with that. In fact, on page 19 of Dr. Williams' testimony in our Exhibit 4, one of the questions that he's actually asked by defense counsel is, all right, so he may have had some type of aggravation to whatever he had ongoing before. You can't necessarily link the rotator cuff tear to the accident. Is that true? Well, and that's where he says, can I say it happened to the accident? No. Can I say it didn't happen? No. In that question itself, it basically states, I agree that there would have been an aggravation, or did it cause it all? Well, the jury instructions are that if someone has a pre-existing condition, it can be made worse. It doesn't matter how small the tear could have been before or how bad the arthritis in the left shoulder was before. The jury believes that a significant motor vehicle accident made that condition worse, made the symptoms worse. And a board-certified orthopedic surgeon agrees that the physical examination after the accident was different than before. And that jury has everything they need to find in favor of the plaintiff. The standard this time is not beyond a reasonable doubt for the plaintiff to prove. It's really beyond a reasonable doubt for the defendant to show that summary disposition should be granted in this case. So, Your Honor, if we take all of the injuries together, if we look at all of the evidence, there are clear questions of fact here. All of the injuries should be allowed to move forward because it's not any one injury, it's the injuries arising from the accident. And Your Honor, I don't know if you have any specific questions. I feel like I'm babbling on and I don't want to waste your time.
Well, let me ask you, I mean, there isn't any doubt that the, whatever complaints existed regarding the knees, that the knees alone wouldn't meet the threshold. Would you agree with that?
I agree with that, Your Honor, yes. By themselves.
Same for the thumb, same for the wrist, same for the hips.
I would agree that each individually correct. There would not be, there wouldn't be a lawsuit filed.
And if the only injury were to, as described, the knees, thumb, wrist, and hips, that the four of those together wouldn't meet the threshold.
Your Honor, only because I'm a plaintiff's attorney do I hesitate in agreeing with you, but I would say
these four relatively minor complaints only take on significance as they're combined with the shoulder, sternum, and ribs.
correct, Your Honor.
Okay, but in combination with the more serious of the injuries, the ones that the more serious of the injuries, that they can still be considered by the court as I look at the whole. That's your position.
It is, Your Honor.
And with respect to the treating physician's unwillingness to say categorically that the accident caused a specific injury, such as the shoulder, or led to the shoulder surgery. Your position is that the doctor validating that the accident could have caused the injury, coupled with the plaintiff's testimony that it didn't hurt before and it now hurts afterwards, is sufficient to satisfy at least the burden of showing that the injury was causally related to the accident.
Your Honor, I think it's a little bit more than that. Remember that Dr. Williams had seen Mr. Rulowitz 2 times before this accident, in January and February. He did range of motion testing, did full exams. Mr. Rulowitz's physical examination was worse after this accident. So that's objective evidence based on Dr. Williams' testimony that even his range of motion was worse. So it's not his subjective pain complaint, it's the actual examination itself is different. So we have the plaintiff saying that he felt better before the accident and obviously felt worse afterwards. We have the examination from a certified stating that. There was no atrophy of the muscle, which is usually indicative of something that is chronic in nature, because we absolutely know there's no question that there was a tear there that had to be fixed. And then we have the testimony from the doctor saying that this type of accident can cause rotator cuff tears. So I think there's a little more to it than simply the plaintiff saying it was worse and a doctor saying, well, yeah. If the standard is, rotator cuff tears are difficult. The reason is that there's a lot of tendons, there's a lot going on there. If this was a broken bone, I'm sure the doctor would say, well, I'm sure it wasn't broken before. But even some treating orthopods would say, well, I didn't, maybe, yes, the bone could have been. So without seeing the actual incident happen, having lived with Mr. Rulowitz beforehand, there's some doctors who will say, well, I can't say for sure. But in reality, it's up to the jury anyway. Because if Dr. Williams said 100%, this injury was caused by the accident, 100%. I have no question in my mind. The jury could still not believe it. They don't have to find simply because the doctor told them. Here, Dr. Williams didn't testify it didn't happen. And that's, I think, the premise that the defense attorney is working based upon. He was not asked, are you sure this didn't happen? And then Dr. Williams said, you're right. Sure. Instead, he said it may have, it may not have. And that's simply because it's a rotator cuff tear and Mr. Rulowitz is in his 60s. And that's for the jury to decide whether or not somebody in their 60s automatically has degenerative tearing, or was it caused by this accident?
Thank you. So, Mr. Giordat, let me ask you, in order for a treating physician to make to express an opinion that a particular physical condition categorically was caused by an accident, doesn't he have to believe what his patient tells him?
Maybe, but that's really not the question, Judge. Categorically is not the standard of proof. This is not more likely than not. The burden of proof, and that's where the misunderstanding, which I'm hearing today, I've been doing this for 30 years, Judge, and I can tell you the burden of proof is simply this: more likely than not. It's not categorically, it's not beyond a reasonable doubt, it's certainly not possible, it's certainly not may have, it's certainly I can't say either way. The burden of proof is this, Judge. We presented a motion for summary disposition challenging these issues. It's incumbent upon the non-moving party to come forward with substantively admissible evidence. And what is that, Judge? Under MRE 702, which we quoted in our brief, requires that any expert can't testify to pure speculation. And if he can't say one way or another, that's pure speculation, Judge. Pure speculation. Possible, pure speculation. May have, pure speculation. Judge, that's exactly what we're talking about here. And that's why the deposition was 2 hours long, because they kept trying to get him to say something he wasn't comfortable saying. Judge, I don't know how I can be any clearer when it says, question, tendon tears can occur traumatically or over time. True? His answer, or both. And I say, or both. Do you have any idea what happened here? Answer, I don't. If that's the case, he can't say how this tendon tear occurred. And here's where counsel is taking a little leap of faith here and a little liberty with the evidence. The only evidence of any injury we have is the MRI and the tendon tear. So the fact that he can't lift his arm one way or the other, whatever Dr. Williams thinks somehow makes a difference, is irrelevant, because Dr. Williams never testified as to any injury. The only injury we have here that we talked about during the 2 hours we deposed him was this tendon tear. And what does he say? He can't tell if it's related. That's it. End of story. There's nothing more to talk about, Judge. I don't know how to make that any clearer other than that. The requirement is more likely than not. Judge, if we had doctors coming in and all they had to say, it's possible, That may have happened in the accident. Would there ever be summary disposition? There would never be. You know why? Because that's not the standard. That's clearly not the standard. Not only that, counsel doesn't come up with any case that tells you could have, may have, I can't say either way is somehow the standard. It's not the standard. Judge, I don't know how to explain this any simpler than that. And when we get to the x-ray situation, assuming what counsel's saying is true, then a misdiagnosis somehow automatically creates an issue of fact. Judge, that's not the case, and that'll never be the case. We know here that this was a misdiagnosis, and somebody took a closer look at it with a better imaging technique, the CT scan, and clearly related it to something that happened before the accident, which to this day, Judge, we've never heard an explanation why he lied in his deposition and why somehow this prior injury is not related. So Judge, when you take a look at all of that, this claim regarding the fractured sternum, that's nonsense as well, because I sent an interrogatory to him. He's a delivery driver. That's what he does for a living. He delivers paint. When was the first time you drove? And he says, I don't know, 6 months when he went back to work. Well, that's not true. He was up and able and around and driving a week after the accident. And how do we know that? Because he got a speeding ticket a week after the accident. So to claim he's somehow off of work because he can't drive is an absolute lie. He's driving the car a week after the accident. There was nothing wrong with his sternum that led him or prohibited him from working. So Judge, when you look at this in a nutshell, and I have all the quotes there, that's really simple. He doesn't provide you with any quote from Dr. Williams that says, more likely than not, which is the quantum of proof required in response to a motion for summary disposition, to avoid it, that is, they don't provide it. Why? Because it's possible. It may have. Dr. Williams was quite honest. You can't tell. And if you can't tell, then you can't relate it to the accident. And if you can't tell and can't relate it to the accident, how do we give that to the jury? If we give that to the jury, then every personal injury case from here on out is nothing more than sympathy, because none of it has anything to do with the facts. Thank you.
All right, so I will acknowledge that the plaintiff has a significant uphill burden to convince a jury of his injuries. But Mr. Girodat, I find the very quote that you highlight in your reply brief to be sufficient to defeat summary disposition. When you look at the history and the facts of what we do know, the accident certainly was a factor in leading to the right shoulder surgery. It appears to, yes. Granted, there's other testimony where he equivocates. That is sufficient for me to create a question of fact. I'm going to deny the motion. Thank you.
Thank you.
Thank you.
Have a good day, gentlemen.
Thank you, Judge.
Your Honor, would you like me to just submit a order under the 7-day rule then?
Yes, please.
Okay, thank you.